Hi everybody, welcome back. This is Sean Sundal, and today we're going to be discussing legal privileges, specifically the attorney-client privilege. Here's my disclaimer. As most of you already know, I am not a licensed attorney. I'm a private investigator. I'm also an off-duty law enforcement officer. I teach at the local community college, teach report writing, and some other courses. But I am not an attorney. That is so important to keep in mind while you watch this presentation. Also, I am not legally responsible for any omissions or any acts that you might partake in as a result of you watching this video. The main reason why I have this video out there is because I want to produce a video that discusses just an introductory into the attorney-client privilege rule. Okay, let's begin. Many of you know me as being the author of this book, okay, The California Legal Investigator. This book is available on Amazon.com. Just type in The California Legal Investigator under Sean Sundal. This book was published late 2017, early 2018. It is still being used by others to pass the California private investigator exam. Doesn't matter what year it is, the information holds valuable every single year. On chapter 26, and if you have the book, please revert to that chapter. Chapter 26, I discuss a whole lot of legal privileges. There are many that I discuss. I do discuss the attorney-client privilege. And I'm saying attorney-client, but in my book, I call it the lawyer-client privilege. You guys, it's the same thing. Attorney, lawyer, the same term. I discuss in that section what exactly it is. However, some of you have came to me who have taken the California private investigator exam, and you ask for a little bit more. Now, we never discuss what questions, what answer choice combinations are on the state exam in California for the qualified manager for private investigators. We do not discuss any exam so-called secrets. What we do discuss is topics. And the topic that is often asked of me is, Sean, can you discuss the work product rule? So that tells me that the exam is shifting a little bit and changing some of the verbiage around. But look, you could change around the verbiage all you want. You could change around the facts, but very rarely can you change the rule of law. And as I speak right now in the year 2021, there has been very, very little changes for the attorney-client privilege rule. Matter of fact, during the research for this video, I couldn't find any 2020 cases, 19, 18, 17, 2021 cases. Very rare that you get new case law for attorney-client privilege because this privilege has been out for so long. So I get a lot of questions about work product rule. What exactly is that? I get a lot of questions about confidentiality. When can you release information to other people? And I think the best way to tackle this situation is number one is read the book if you haven't already. But number two is create a presentation like I'm doing right now and create some visual presentations. And by you watching some of these visual presentations in combination with you reading the material, I think you're going to be better off understanding what the attorney-client privilege rule is, what the work product doctrine is, okay, whether or not there's an investigator-client privilege. There's going to be a lot of case law that's going to be thrown out to you. We're going to have lots of discussions about that. In being as detailed as possible and trying to cover as much as possible, this presentation is going to last more or less an hour and a half. What you can also do is if you wanted to skip to a certain part of the presentation, just go to the time stamp in the description box and it'll bring you to a certain topic that might interest you. But ultimately, it is my recommendation that you listen to all hour and a half of this presentation. It's going to benefit you by helping you become a better informed private investigator. You're going to have a lot more knowledge, and once you have more knowledge, you have that strong foundation, that knowledge base of the attorney-client privilege. I think that you're going to make better decisions out there. Guys, we need to discuss the objectives before we begin this presentation. The reason why we're going to discuss the objectives is because this serves as a roadmap. We're going to discuss particular cases, and we're going to discuss certain strategies. This roadmap allows you to understand where exactly we are going to be at a certain place of time during this presentation. We're going to define the legal privilege. We're going to define and discuss the attorney-client privilege. And my objective is that after every micro objective that I discuss in this video, you're going to understand the objective. We're going to define and discuss the work product doctrine. We're going to discuss California Code of Civil Procedure 2018.030 subsection A, and we'll discuss B. We're going to discuss Coito versus Superior Court. We're going to discuss and analyze the attorney-client privilege cases involving private investigators, specifically private investigators. You guys, I pulled up City of Petaluma versus Superior Court of Sonoma County. I found Fireman's Fund Insurance Company versus Superior Court. I found Magill versus County of Madera. You're going to love this one. People versus Meredith. And by the way, about 2 of these will be California Supreme Court decisions, and the rest will be California Court of Appeal decisions. And we're going to discuss the existence of a work product doctrine, attorney-client privilege, and this is going to be for private investigators. We're going to discuss the Business Professions Code section 7539 subsection A. And finally, we're going to discuss and analyze Flynn versus Superior Court. This is a 1997 case. What is a legal privilege? In order to understand what a legal privilege is, I think it's best that we break the sentence down into different parts. What does the word privilege to you mean? Think about it. Well, to me, a privilege is a right to be able to do something. And perhaps it's a obligation on a government agency to acknowledge my right. Here we have the word legal, so we can assume that there's going to be a court obligation to have me maintain a certain right that I have. In general, legal privileges deem certain communication confidential because there's a great and important society interest in doing so. Imagine there's a man and woman and they're having this conversation, and other people might learn about the conversation, and if they do, well, there's some privacy concerns with this man and this woman. It might be embarrassing, the communication, but there's a reason why that they're only communicating with the other person and not the whole public. They want to keep this information private and confidential. So with the legal privilege, you're going to have the judge that's going to be supervising the case and perhaps order this man and woman to disclose what the confidential communication was about. Well, if it was confidential, then nobody else should know about it, right? So what the legal privilege basically does is it creates this huge wall. On the upper right portion of the screen, you have the jury, okay, who's about to hear the evidence that's about to be admitted by one of these parties. The legal privilege, many times, okay, when there is a legal privilege, it does not survive compulsory disclosure. And what is compulsory disclosure? Well, it's a court order. The judge can simply order somebody to do something as long as it's a reasonable order and the judge has the authority to do so. But with legal privileges, the judge is prevented many times from requiring the party here to disclose what the communication is about. In essence, the legal privilege protects right here this man and woman and what was said. On this slide, we're going to talk about the attorney-client privilege specifically. You're going to hear out there, or people are going to ask what a work product privilege is. You guys, this is a made-up term. There's nothing in California that's called a work product privilege. So let's remove that from the dictionary. There's something called a work product doctrine or a work product rule, but there is no work product privilege. So this is how the attorney-client privilege works, and the best way is to create a visual representation. I think this is going to help you remember. So on the right you have the attorney, and on the left here you have the client. Well, this client is deciding, well, should I disclose information to this attorney? Should I or should I not? And many people are hesitant to do so because they might think, well, if I disclose information to attorney, this attorney might tell somebody else, and that communication that might be disclosed might be embarrassing, humiliating, maybe degrading. So having that in mind, without a privilege, a lot of people wouldn't want to even talk to an attorney. Now, let's just say this guy knows that there's attorney-client privilege. Well, if he knows that there's a privilege, he knows that the communication between him and the attorney are going to be privileged. They're going to be confidential. Even in court, very rarely, well, I won't say very rarely, but once there's attorney-client privilege established in court, rarely does the court disclose in open court what that communication was about. When the client reaches out to the lawyer, he or she must do so in confidence, in a private setting. So if this client reaches out to the attorney and they have a conversation about a legal issue in Starbucks or some type of facility where there's people walking around, people nearby, well, you did not intend to maintain confidential communications with the attorney. Therefore, everything that you disclose to this attorney is open season for other people. That communication is not privileged anymore. You waive that privilege. Many times people sue others and they have discussion with the attorney, and then they go on social media, maybe YouTube, and they disclose what that communication was about. Well, when you do that, you're waiving the right to the attorney-client privilege. Not a smart idea. So, what reasons, in order for the attorney-client privilege to be relevant to you, what information or service must you seek from the attorney? Well, number one is you have to seek legal assistance from the attorney. And notice on the lower left, I had the box that says providing pop-up. That pertains to the attorney. So if the attorney is providing legal assistance and that communication that you made to the attorney was made in confidence, the attorney-client privilege is alive. So I'm going to summarize. You need a client. See, number one, you need a client and you need an attorney. The client has to communicate with the attorney in confidence. Confidential matters. If you talk to an attorney when the door is wide open and the general public is there, there could be an argument that the communication was not private, okay? And for that reason, many times attorneys will close the doors or they will not let people within hearing access. I'm talking about other clients. They won't let there be a waiting room that's right next to the legal office where you're going to have a discussion with the attorney. Okay. And number 3, the reason for you reaching out to the attorney must be for the purpose of obtaining or seeking legal assistance. And concentrate on the box on the left, which is providing. And as long as the attorney is providing legal assistance to you, okay, that communication is going to be privileged under the attorney-client privilege. Those of you watching this video, you are most likely a private investigator applicant, or you are a licensed private investigator. And I also know that there's a handful of you who are licensed attorneys or Juris Doctorate holders, or even paralegals. But all in all, you're interested in wanting to know what the attorney-client privilege has to do with private investigators. And we're going to get to that. And even if you are an attorney, you learn in law school already about the attorney-client privilege, but I'm going to actually cite authorities that you can also research on your own that will give more substance to the attorney-client privilege and the work product doctrine. I'm going to say that again, the work product doctrine. So the work product doctrine is a subset of the attorney-client privilege. When you are dealing with clients, if you're an attorney, there's a good chance and there's good opportunities for you to create work products. And that's what we are discussing on this slide. What is privilege and what is not? And you're going to also see that there's different tiers of privilege. Well, there's not different tiers of privilege. There's an absolute privilege, and there is something that is more of a safeguard. But we have to be really careful on what we call some of these terms. If we call them privileges, well, legally, significantly, that actually means something. And if we call something a doctrine, that is something that's less of a privilege. Remember these elements from the last slide. There's obtaining, there's seeking, there's providing. What am I going to put in the middle of this visual representation? Guess. I'm putting legal assistance. Legal assistance. Remember, the attorney-client privilege works in this fashion. Client reaches out to an attorney and communicates. That communication, as long as the intent of it was for that communication to remain confidential, okay, to an attorney, and as long as this person sought out this communication for the purposes of obtaining or seeking legal assistance, and also, or the attorney is providing legal assistance to this client who needs a legal assistance, well, that realm of communication, that circle of communication, that safeguard is known as the attorney-client privilege. That communication is private, it's confidential, and it's not supposed to survive anywhere outside of the courtroom, actually anywhere outside of the judge's chambers. So if you are the private investigator, you're learning about private investigators, how do you get into this barricade, this wall of private communication? Well, you probably will not get as close as the attorney-client privilege, but there's something called the work product doctrine. Now, right here, I put a red line to providing. Okay, so if you're a private investigator, if you're providing legal assistance to the client, well, that communication is going to be privileged. However, most private investigators, now I do have a handful of licensed attorneys who also decide to become licensed private investigators. They can provide legal assistance, but most of us private investigators, we don't have a Juris Doctorate, and if we do, we are not licensed attorneys, so we cannot, in most cases, provide legal assistance, right? But there's other things that we do. For example, we might observe an interview. We might hear something. We might see something, take pictures. We might conduct a report like this fellow is doing right now. He's typing out a report based on his findings, okay? we have another fellow here who's taking, it could be video and it could be pictures as well. There's going to be a product in the end result of this. And we have this other gentleman that's conducting an interview. It looks like he's audio recording the interview. So here you have a report. You have somebody that takes photos, which those photos will eventually maybe become on a disk or they'll be on the cloud. And you have somebody recording audio, which can be on a cloud. It can also be on a disk. All of these three things I mentioned, and we're not going to restrict a work product privilege to these three things I just mentioned, but all these things are work products. You see, all of the case studies that I have researched for this presentation, the judges hold very, they want to hold these work products as something that's kind of like sacred. And they continue to state that the reason why we want to keep this information secret from the adversary party is we don't want to have the other party have a disadvantage. We don't want to have that lazy attorney just feed off the work products of the private investigator or even of the attorney. Okay, it just brings a lot of laziness. And you see the justices and the judges in these appellate cases discussing that. They even use the words laziness. They don't want to have lazy attorneys. If you are conducting, now I want to direct you to the bottom right portion of the screen. If you're a private investigator, okay, and you are interviewing somebody, and those interviews are attorney directed, so the attorney wants you to ask certain questions, and you as a private investigator, you are being supervised very carefully by this attorney. The questions that you ask are in the realm of the attorney providing legal assistance, because the attorney has to ask questions, right? And this attorney needs to get answers to understand the merits of the case, because maybe this case isn't worth pursuing. So what we've seen in these case studies is that the communication between the private investigator and the client fall into the attorney-client privilege, and they're one step above the work product doctrine. So not only is this a product of a work product, but it's also a portion of the attorney-client privilege. So that communication is confidential and it does not survive the courtroom. It may not even enter the judge's chambers. Okay, but that's not always the case. Now that's only if the private investigator is interviewing the client. Okay, if the private investigator is interviewing a witness, okay, that statement, maybe the private investigator is memorializing the interview into a report. Well, that report is going to be a work product, and that communication between a witness who's not the client, that's going to also be a work product, because when you're interviewing a third party, the witness, through a private investigator, you're not providing any legal assistance. Okay, so that interview will not receive the attorney-client privilege, only if in most cases, if it's a client interview and there's specific questions that need to be asked for the purposes, and let me direct you down to the bottom right portion of the screen, purposes of providing legal assistance. The work product doctrine was codified in California Code of Civil Procedures 2018.030 subsection A and subsection B. Subsection A tells us that a writing, and I'm going to read it verbatim actually, a writing that reflects an attorney's impressions, conclusions, opinions, or legal research or theories is not discoverable under any circumstances. Ladies and gentlemen, it says a writing, okay? So as long as the writing reflects the attorney's impressions, conclusions, opinions, or legal research or theories, it's not discoverable. It has to be a writing, and a writing can include an email. Now, a writing is not something where you audio record, an interview. Okay, that's not a writing. That would fall under it would be less of a protection under the attorney work product doctrine, which we'll discuss in a minute. If the issue at large falls under subsection A, then you get absolute protection. And the writing it's not discoverable, which means it may not even enter the judge's chambers. Okay, and it certainly will not enter a deposition. Now, there's always that possibility that communication, that writing. Now here, remember the writing. There could be an in-camera interview, okay, the judge's chambers, and both parties will get a chance to see whether or not this should receive absolute protection, whether or not this is an attorney work product that deserves the protection of subsection A. Okay, but there's a great amount of protection here. As a private investigator, you are most likely going to fall into the subsection B. Okay, because look, most of the reports that you conduct or that you compile, they're not going to be a writing that reflects an attorney's impressions, conclusions, opinions, or legal research or theories. It's not. But it's going to be a work product. Remember, we don't want the other attorney, the other side, to have an unfair advantage over the hard work that we do. So subsection B would most likely cover most of our circumstances. So you're out there taking pictures, even if you're interviewing witnesses out there, okay, you're going to get the protections of subsection B. Now, there's not as much protections as subsection A, but there's something here. Now, I'm going to read you off subsection B. It says here, the work product of an attorney other than a writing described in subsection A is not discoverable unless the court determines that denial of discovery will unfairly prejudice the party seeking discovery in preparing that party's claim or defense, or will result in an injustice. Now, if you fall under subsection B, then the burden of proving that this is a attorney work product is on the attorney who you will be working with. So I want you to imagine the scales of justice. To the left is the word grant, and to the right is the word deny. Grant means that the judge will grant you, okay, the protections that are afforded in subsection B. The word deny that I have here, it means he or she will deny it. Now, on the scales of justice here, we have injustice that just fell down the scale. And then we have unfair prejudice. And we are weighing unfair prejudice and injustice with the facts of the case. If you fall under subsection B, then the attorney who you are working for has a lot more work to do in order for that, whether it's communication or other form of work product, to be remained as confidential. Let's talk about Coito versus Superior Court. This is a 2012 case. This is actually a California Supreme Court decision. The opinion has bearing on California cases as we speak currently. This is a very sad case. A mother suffered the loss of her 12-year-old child in a drowning death. She brought suit. State of California. State of California's Attorney General's office sent 2 deputy investigators to investigate the incident. They conducted a total of 4 witness interviews, and there was audio. And the other party, the plaintiff, wanted to have, she wanted the interviews. She wanted to know what the content of the interview was. Remember, they're audio recorded, so she probably wanted that disc. Around 2012, the audio was most likely on a disc. So let's talk about what the justices ruled here. They held that witness statements obtained through an attorney-directed interview are entitled to work product protection. Remember, we discussed that a couple slides ago, that when the attorney directs a private investigator to ask certain questions, there is work product protection. Now remember, if it's witnesses, then there's less of a protection than if it was an attorney-directed interview towards a client, because most likely the client is attempting to seek legal advice and the attorney is providing legal advice and cannot provide a legal strategy unless he or she knows the facts of the case, which would involve some self-disclosure from the client. The statements must be inextricably intertwined with the attorney's impressions. The statements that the private investigators gather, and here these were state attorney general investigators, but this applies to private investigators as well. The statements have to have some type of connection with the attorney's impressions. And notice on the bullet point here, it says attorney's impressions. You guys remember where that word came from, impressions? Remember? This falls under the work product doctrine. Remember, there's impressions, there's conclusions, opinions, or legal research or theories. And these elements are connected to the attorney's work. Whenever the attorney is gathering information, documents, work products, okay, that will reveal his or her impressions, conclusions, opinions, or legal research or theories, that work product falls under an absolute privilege. Okay, so here the attorney in this case, who's defending this privilege, okay, doesn't have to fight as hard. This attorney doesn't have the burden of proving that this is actually a work product. Okay, it's the other half. So I want you to imagine that this gear over here is attorney. We're looking at the bottom right of the screen, and then we have the private investigator. Okay, you guys, the statements that are sought needs to be inextricably intertwined. Okay, just like the gears, there needs to be that connection. And this is also what the justices said. In light of the origins and development of the work product privilege in California, we conclude that witness statements, and I'm reading verbatim here, obtained as a result of an interview conducted by an attorney or by an attorney's agent at the attorney's behest constitute work. I'm going to read some of this again. As a result of an interview conducted by an attorney or by an attorney's agent at the attorney's behest constitute work. Remember how I said that even though there was attorney general investigators conducting the interviews, this also applies to a private investigator, because here, or you can, in other cases, you are the attorney's agent. Okay, it says right here, by an attorney's agent. Okay, so as long as you're working under an attorney, if you represent or you're working for the attorney, you become the agent. And in light of the origins and development of the work product privilege California, okay, those statements are constituting work, therefore they are part of the work product doctrine, and you'll fall under subsection A of 2018.030. Justices also mention this. We conclude that witness statements procured by an attorney are entitled as a matter of law to at least qualify work product protection under section 2018.030 subsection B. Okay, so at the very least, you guys, and it says here, witness statements, subsection B. The attorney's going to have a lot more work in this fight to not get these statements admitted into evidence, but at least there are some protections here. Let me direct your attention to the City of Petaluma versus Superior Court of Sonoma County. This is a First District California appellate case in 2016. What we have here is we have a discrimination, and I think it's a sexual harassment lawsuit. The City of Petaluma hired an investigator, and this investigator was a licensed attorney. The facts don't disclose whether she was a private investigator or not, but this person was a licensed attorney who was hired for the sole purpose of investigating the merits of the case. This investigator was told not to provide any legal advice at all, but just to investigate. And when she's investigating, she's communicating with witnesses, and she is also compiling a report. So let's discuss what the appellate court found here. Now, it's also important to mention that this is only a fact-finding objective. That's it. So when the firefighter brought the lawsuit for discrimination, she sought to compel the city to produce the investigator's report. She wants to know what is on this report. Here's the Petaluma Fire Department. I don't believe that this is the firefighter that brought suit. This is a picture that I obtained on the Petaluma Fire Department. Here you have a female firefighter standing next to one of the fire trucks, but I don't believe that this is the same person. This is just for illustration purposes. So evidence code 951 was cited, and this is very important that we quote verbatim. Who's the client? Okay, well, the client means a person who directly or through an authorized representative consults a lawyer for the purpose of retaining the lawyer or securing legal service or advice from him in his professional capacity. So the issue here is, well, this investigator, who's an attorney, was hired to investigate the merits of the case, not the merits of the case, investigate some facts, to investigate whether or not something actually occurred. Because if something did not occur, then the city of Petaluma would have a valid defense and a strong defense. What the appellate court highlighted out of 951 evidence code is that when the purpose, okay, that you become a client for the purpose of retaining a lawyer or securing legal service. So the question is, well, what is legal service? And is interviewing different parties, collecting notes, doing everything but providing legal advice, is that securing legal service? And the answer that we will find in this case is yes. Why is that important to you as a private investigator? Well, you are part of the circle of trust with the attorney, with an attorney. You're helping the client secure legal service by perhaps becoming the bridge of communication to the attorney. Okay, this case did not discuss, and I'm going to reiterate, private investigators at all. It mentioned investigator, but remember, you can fall into the circle of privilege as well. And before we leave here, on this slide, the attorney-client relationship exists when an attorney provides legal service without also providing advice. And that's the point that I'm driving home right now. Whenever I discuss some of these cases, I always want to show you a visual representation. Here, based on a real estate listing, I was looking up the the address for Front Gate Plaza in Lancaster, California, and based on property records, based on a listing, we have 1740 East Avenue J, Lancaster, California. That is Los Angeles County. But I just want to give you a layout of where I believe the litigation occurred based on the event. So here there was some type of storm damage, and I'll discuss a little bit more facts of this case. But normally, especially those of you who have worked in law enforcement, these large shopping centers they're owned many times by a corporation or LLC, but you also have a management company that does all the accounting, all the bookkeeping, and with that comes embezzlement, comes fraud. But here came an actual claim for storm damage. Now, I'm not saying that the LLC that operated this company committed fraud. All we're discussing here is the case law. Thank God for Google. I always like to research the addresses of a lot of these cases. Now, again, I'm going to reiterate, it's not for sure that the property we're speaking about is the property that I just showed you. On an older broker listing for the property, that's the address that pops up when you type in Front Gate Plaza LLC. So you could take it for what it's worth. So this is going to be Fireman's Fund Insurance Company versus Superior Court. As a 2011 case. This is the 4th district. It seems like a lot of these cases, the California appellate cases, are coming out of the 4th district. So what we have here is Front Gate Plaza LLC. Okay, they own the property. So apparently they own the property that I just showed you. Okay, whether that's factual correct or not, I don't know. But it was just used for illustration purposes. Front Gate Plaza LLC owns a property that is in Lancaster, California, and the management company of the property is known as Primero Management Incorporated. Primero Management Incorporated. And what they do is provide management and accounting services for Front Gate. So there's a whistleblower that worked for Primero. Okay, his name is Chand. Okay, and what Chand said, and Chand, he's one of the head bookkeepers, accountants. This guy had he was in management. Okay, he said, or he notified the attorney for Fireman's Fund and said that Front Gate is making a fraudulent claim. So once again, Front Gate Plaza owns the property in Lancaster, and Primero is the management company. Chand works for Primero. And we have private investigator Pamela Pierce that's assigned to the case, and she runs Pierce Investigations. I last researched her company, and according to BSIS records, she's still in business. She's doing a great job out there. So that's Pamela Pierce from Pierce Investigations, and it looks like she had a contract at that time with Fireman's Fund. Okay, and she contacted Chand. Okay, so think about this. You have Pamela Pierce, who's a private investigator, okay, and then it looks like that there might be some involvement with Fireman's Fund attorney. So it looks like they hired an attorney, and then Pamela contacts the whistleblower. But what you're going to ultimately see is the whistleblower is a witness. Okay, remember, because the whistleblower is not the witness, the whistleblower is not the client, there's no room in the attorney-client privilege, in that circle of trust, that circle of privilege. But remember, there might be grounds for the work product doctrine, which we'll discuss. So Front Gate sought to compel Fireman's Fund to produce Chand's original documents, okay, that he gave to Pierce, and the communication between Pierce and Dubs. Okay, so Dubs is the fireman's attorney, and when I say fireman's, I'm referring to Fireman's Fund. So let's see what happens. This is a deposition, and it looked like that there was a form of interrogatories. These are a line of questioning that's asked. And if you've ever been in a deposition or had to answer interrogatories, you can easily see 40 pages, 50 pages, 70 pages, 100 pages. There's a lot of questions that seem not even relevant to the case, but the depositing attorney believes that they're relevant, therefore publishes those questions and demands that you answer. So here, question 7 asks Dubs to disclose her discussions with investigator Pierce, okay, regarding how to pay Chand $1,000. So remember, Dubs is the attorney and Pierce is the investigator. And what ended up happening is Dubs paid Chand $1,000 to travel, I think it's to San Francisco area. What this $1,000 fee covered was time off of work and other travel expenses. To the other party, they might look at this as maybe a bribe, but it's not a bribe. This is a way how to compensate Chand for traveling over there and having a discussion about the case. So this is what the court's opinion is. If the question implicated Dubs' legal opinion regarding Chand, then the communication is privileged. Remember, I discussed that if you're asking a client or you're gathering information for a legal opinion, okay, then that's privileged communication. But here, Chand isn't even the client. He's the whistleblower. He's the witness. The court mentioned that if the answer to the question simply involved Pierce's communications to Dubs conveying Chand's desire to be paid and or the means by which he would prefer to be paid, the privilege would not apply. And why would that privilege not apply? Well, there's just a desire to be paid, and that's it. Where is the seeking for legal services? Well, that's not here. And because it's not there, that is not going to be privileged communication. Let's talk about Magill versus County of Madera. This is a 2001 case. This is a Court of Appeals in California, 5th District case. This involves a fatal hit and run. You guys, this is one of my favorite cases to discuss. Why is that? Well, because this case just demonstrates why it's not a good thing to run a home office. Now, that's a totally different subject, running a home-based business, but this can show you that if you do, this can happen. And I'm not discouraging you guys from having a home-based business, but there's always this possibility. And hopefully by the end of the discussion of this case, you have an understanding on where you should put your files. So in this case, we have Magill. Magill is the attorney, and you also have a private investigator named Stevens. The client, who in the case is often referred to as the client or anonymous person, was possibly involved in a fatal hit and run collision. Client sought out Mr. Magill and wanted Magill to reach out to the California Highway Patrol and ask if his client is involved as a suspect in the fatal hit and run. And the client wants Magill to provide some details such as photographs of his, meaning the client's vehicle. And it looked like this is one of those cases where the client is fishing for information, doesn't want to get in trouble, so reaches out to an attorney to see what the evidence against them is currently. Okay, and with some with some cases, this is common. This case also illustrates to those of you who are still in law enforcement, especially who have management roles, it illustrates the importance of knowing the work product doctrine and the attorney-client privilege. Remember, with the attorney-client privilege, we have the attorney. Well, the private investigator just floated in because there's a discussion about private investigators, but we have the attorney, we have John Doe, okay, the opinion from the court also calls the client John Doe, by the way. So in the circle of trust, circle of privilege, or purported privilege, we have John Doe, we have attorney, and then we have the private investigator. And you guys, this attorney, it looked like he did a diligent job, diligent work in trying his best on not having the client self-incriminate himself. But it looks like in this case, things went to a bad turn. So this is the circle of trust. This is the circle of privilege. The attorney-client privilege that we want to keep in here. As the closer that we're able to keep our private investigator in this circle, the better off this privilege is going to withstand the demands of the courtroom. So what our attorney Miguel did is he created a folder. Okay, the client here had some newspaper articles regarding the collision and gave it to the attorney. The attorney put that in a folder. This is also a bad thing, you guys, because people who are suspected of committing crimes, or people who commit crimes, they often want to keep some sort of media report, media release on the crimes that they were potentially involved in, as perhaps maybe as a symbol that they are related to the case, as a form of, sometimes a form of treasure to those who are sick-minded. But they do this sometimes. So the client here gave that document to the attorney, and let's see what happens. So he writes on the folder John Doe, okay, because as far as we know, he doesn't even know the name of the client. I mean, between us, we know that he probably does, but the client really does not want his name disclosed. And he tells the private investigator, he tells the attorney, do not disclose who I am. Don't even disclose my address. The attorney gives this John Doe folder to our private investigator, Stevens, and Stevens meets with the client at a particular location, and at the client's request, he photographs the vehicle. Now, I know in 2001, there probably wasn't good quality pictures that were taken with cell phones. Here, you guys, this is just for illustration purposes. This is not the actual vehicle involved. But we do know that Stevens takes photographs of the vehicle that the client has, and actually videotapes the vehicle as well. So there's a vehicle involved. I think it was a white van or off-color van and a trailer. Private investigator meets John Doe to take these medias, to take this form of media. As of right now, at this time, the private investigator he knows about the addresses. So what he does is he develops the pictures. He puts the pictures on a disc and the video on some other disc. But on the pictures, okay, he actually labels the pictures with an address, and that address was actually incorrect, and it infuriated. It looked like, per the opinion of the court, the highway patrol officers that were investigating the case. Okay, they were wondering, why did you give us the wrong address? He stated it was just a mistake. It's not to throw you off. So investigator Stevens now has the John Doe folder. He puts the photographs in the folder, but he redacts the license plate. And with with the video camera, okay, he doesn't do any modifications to it, as far as we know right now. He goes to the California Highway Patrol office, talks to the investigating officers, and shows the redacted photo. And now there's a redacted license plate on there, and the investigators start demanding they want to know what's the license plate? Where did you take these pictures at? And what the investigator Stevens does is this. He's really smart here. He said, "Hey, this is attorney-client privilege information. I was told not to discuss this." The California Highway Patrol officers keep pressing him and tell him, "Hey, you are concealing a felony. Okay, this possible felony hit and run, fatal." And well, like here's our private investigator stands his ground and says, "I'm not going to release the information that you're seeking. If you want the information, you're going to have to talk to Magill." Okay. The investigator also refuses to disclose the name of the client as well. Highway patrollers keep pressing on. At this time, the highway patrol officers, they're actually developing a case. They're developing probable cause for a search warrant based on the information that John Doe presents. John Doe, the private investigator, the information that he presents. This case gets a lot interesting. The highway patrol officers were able to secure a search warrant for Magill's residence, okay, their residence, and private investigator Stevens' residence. They were able to show that most of the work was conducted from their home office. Therefore, they got a judge actually approved search warrant for their offices. Before that was granted, there was some heated discussions between the deputy district attorney and Magill. The district attorney told Magill, "Hey, you need to disclose who your client is. You need to disclose what you talked about. You need to disclose the addresses as well." And Magill said, "No, this is privileged communication." And they went back and forth. District attorney kept demanding that information, and our attorney Magill kept refusing to provide that information. So it looked like the judges that were involved in this case, they saw that there is some heated discussion. So the judge actually assigned it's called a special master to the case. And special master is in a similar category as a referee. The qualifications are very similar. Special master's qualifications, you have to be well versed in the law that is at dispute. So you would think that the court appointed somebody that's qualified, somebody that knows the law, and apparently there is an issue with this special master. When Highway Patrol was going over some of the things that they seized, when the special master was going over the objects or the items that the Highway Patrol officers seized, they were yelling out loud what the items were. They were reading off names and everything like that. So when you do that in the presence of law enforcement, you're giving the prosecution an unfair advantage. And there was a specific reason why the judge assigned the special master. He didn't want any unfair advantage for the prosecutor. So this is what the justices said in this case after reviewing. The videotape and unredacted photographs lack any communicative content, and there's nothing in these items which could be interpreted as a confidential communication from John Doe to Magill. Remember, if we can prove that there was an intent, okay, a private intent from the client to the attorney, okay, to discuss a legal solution, a legal issue with the licensed attorney, okay, that communication would be privileged under the attorney-client privilege. But are videotapes and unredacted photographs, is there any communicative content within the realms of the attorney-client privilege? Well, the justices here did not believe so. Now here's a picture, just for illustration purposes. What do you think the lady here is communicating? Think about it. In my opinion, she's communicating, I just got involved in a collision. I'm not at fault, but you are. Okay, that's the communicated message. But you see here, in Magill versus County of Madera, the private investigator took pictures of the vehicle, okay, not of the client. There was no communicative content in there. This picture, there is. Hey, we got in a crash, and you're at fault. So a picture like this can easily pass the test for attorney-client privilege, depending on how the attorney presents the information. Justices also said this: had the photos and video been sent to Magill to assist him to form his impressions, opinions, or conclusions about the case, then there would be an absolute privilege. Remember, we keep discussing the work product rule, attorney-client privilege, and these words keep popping up, these phrases: impressions, opinions, or conclusions about the case. Okay, under the work product doctrine, okay, if the information that the attorney receives, as long as it has something to do with the impressions, opinions, or conclusions about the case, well, you have the absolute privilege. Remember, when there's absolute privilege, many times that communication doesn't even enter the judge's chambers. If not, then you fall under the second tier of the work product doctrine. And remember, there's a separate hearing that has to take place, and that hearing is going to involve, well, if we do not allow this evidence to be admitted, is there some injustice? Okay, is there some unfair treatment here to the other party? The other party going to be unnecessarily disadvantaged? And if so, well, we're going to have to allow this communication, which was private, to be entered into open court. Okay, and when I mean communication, I'm also referring to the work product, the pictures, the interviews. It says here, in an interesting twist, since Magill had Stevens, okay, show the CHP the photos, and he only, remember, Stevens only redacted the license plate number. When he did that, he waived the right to absolute protection under the work product rule. Now remember, under the work product rule, our private investigator Stevens counts in this circle of trust, in this circle of privilege, but because he showed the redacted license plate number, okay, he's waiving the right to absolute privilege. He just disclosed that some of his work product, and when you do that, depending on how much, you're waiving your absolute protection. So remember, when you waive, or when you lose absolute protection, there's also a second tier, that's subsection B. Now let me ask you this: what if you showed the picture of the white van and it blurred most of it out, even the license plate? Okay, would this be following under subsection A? Well, perhaps, but because it wasn't, it's probably under subsection B, and the attorney has to fight for this case a lot more. Okay. Now, the justices did mention that the photographs, they were not attorney-client privilege; they were just work products. This book, The California Legal Investigator, has attracted all spectrums of the private investigations sector. Guys, I get chiefs of police, and it's such an honor to be able to work with these professionals. I get chiefs of police, I get sheriffs, I get command staff, lots of command staff. I get the best detectives. I get homicide detectives, I get arson investigators for fire departments. These are people who have found leads to very important cases out there. They're in the media, they're in books. I'm really honored to help a lot of these people. Having the knowledge that I have the best of the best, the most brilliant out there watching these videos and reading my book, I want to answer as much as I can. See, most professionals who are very brilliant, they're going to want to know, well, Sean, where are you getting this information from? Sean, where does it say that a private investigator is an agent of an attorney? Well, we got People versus Meredith, and I'm going to show you exactly what the attorney-client privilege can do for the private investigator who's assigned to a very important case that needs that level of protection. So in People versus Meredith, this is a California Supreme Court case in the late 1970s. Late 1970s, David Wade was murdered, and there was 3 conspirators that were arrested. They were charged for murder and for robbery. Mr. Wade was robbed of his wallet, and the investigators at the scene, the criminal investigators, couldn't locate the wallet at all. Meredith is the client here. He's a conspirator. So remember the circle of trust, the circle of privileged communication. We have the PI, the private investigator. We have the attorney. Here we have Mr. Meredith, who is the actual client here. Under the attorney-client privilege, remember, privileged communication does not leave this circle of trust, this barrier. It doesn't leave as long as all the conditions are met. Okay. What Meredith ended up doing is this. He contacted an attorney, and he told the attorney, hey, he knows where the wallet's at. Attorney got a hold, and this is a defense attorney, got a hold of a defense investigator. And I'm going to be mixing up the names, defense investigator, investigator, quite often an attorney. When I'm saying defense investigator, I'm also referring to private investigators. I'm referring to private investigator, I'm referring to defense investigator. And that's just so that we can understand how this applies to private investigators. So Meredith hired our defense attorney, who hired a private investigator who was actually a defense investigator. And Meredith had a confidential, well, he had a private conversation with our private investigator named Flick. Okay. And Meredith disclosed to Frick where the wallet was located. Frick goes to the crime scene, locates the wallet in a trash can. After examining the contents, okay, he leaves the scene with the wallet and notifies law enforcement. He hands over the wallet to law enforcement. We will discuss what the legal issues are in a minute here. So the California Supreme Court asked this question. The issue before us, consequently, focuses upon a narrow point, whether, under the circumstances of this case, Frick's observation, that's a private investigator, of the location of the wallet, the product of a privileged communication, finds protection under the attorney-client privilege. If there's protection under the attorney-client privilege, then the communication, that form of communication, when Meredith told the private investigator Frick where the wallet's at, that information can be removed from evidence. Actually, it would not even be admissible, okay, because this is an appellate decision at the Supreme Court level. If if they can remove this piece of evidence, okay, it's very possible that Meredith can be let free, or the issues might need to be resolved back at the trial court level. Okay, so that's the main issue. I want you guys right now, if you have to turn off this video, I want you to use the knowledge, skills that you have learned this far in this video, and apply it to this current situation. You are a defense investigator, okay? And the defense attorney asks you to contact the defendant. You contact the defendant. Defendant tells you the wallet is at 123 Main Street, whatever address it is. You go there and you find the wallet. With the fact that he said the wallet is at 123 Main Street, that communication, would that be admissible in court? Think about it. If you have to shut off the video to give me an answer, do so. Would this fall under the attorney-client privilege? Well, are you, Meredith, if you're a defendant, are you giving this information to the private investigator so that the attorney, okay, who's the defense attorney, can determine what the merits of the appeal are going to be? Well, it almost seems like it is, but think on your own. Is the attorney seeking, okay, to gather certain information and using the private investigator as a proxy to get to Meredith? Is there certain questions that he might want to elicit from Meredith in order to better prepare for the case, for an appeal? Think about it. Well, let's find out if the observation of the wallet, which is a product of a privileged communication, let's discuss if there's protection under the attorney-client privilege. This is not the original scene. This is just for illustration purposes. But you're the private investigator or defense investigator. You're going to the scene. You find this wallet, and your client told you it's there. Is this gonna find protection under the attorney-client privilege? Well, this is what the justices at the California Supreme Court said in their opinion. An investigator retained by an attorney to assist in the client's case is a person encompassed by the privilege and stands in the same position as the attorney for purposes of the privilege. The investigator cannot then disclose that which the attorney could not have disclosed. This is important, solid information, you guys. Here, it almost seems like you have a duty, okay, to invoke the attorney-client privilege, even though you're not an attorney. But here, according to this opinion by the California Supreme Court, you stand in the same position as the attorney. Okay, so if you are pressed into providing or providing testimony as to what the communication was between you and the client, okay, my suggestion here is this: Your Honor, I cannot answer that question. The information that I may possibly produce is privileged communication under the attorney-client privilege. Okay, and then from here, possible that you can go in chambers, and hopefully you have the attorney who sent you out on this project to interview the defendant. Hopefully he's there, and I'm sure he's going to be there to raise any objections, to defend the position that this was attorney-client privilege information. Okay. They also said this: client's communication to the attorney's investigator are within the privilege because the investigator is the attorney's agent. You guys, this is so important. attorney's agent and the client's sub-agent. Client sub-agent, and is acting for the client. Okay? It doesn't matter if you're a contractor, you're the direct employee. You guys, it's almost like you're going to, maybe marriage counseling or something like that. Maybe that's not a good topic. Going back to a physician patient privilege. Okay, you're going to your doctor's office. You call the receptionist. Hi, I'm having problems with my bladder. I'd like to make an appointment with the doctor. You go over there. You check in with the receptionist. The LVN or a medical technician evaluates you, takes measurements, takes your weight and all your vitals, and then you see the physician. But the physician isn't there. It's a nurse practitioner or a physician's assistant, okay, who then might communicate their evaluation on you to the actual doctor. Because everybody that I just mentioned is within the line of reasonableness of being connected, okay, intertwined with the doctor. Therefore, information that you give to everyone else, all these people I just mentioned, are going to be privileged. Just like the attorney-client privilege. You as a private investigator, you're a tool, okay, you're a tool, you're a work product of the actual attorney as well. Going down the opinion, they also said this. Observations by investigators are covered under attorney-client unless the evidence was altered. Right now, I want you to think, did our investigator alter any evidence? If you have to go back, if you have to pause, go back in the story and revisit this moment of the video, then do so. Let's test out how much information you have returned, and I'm confident that you retained a lot. So let's proceed here. This is not the house, you guys. This is just for illustration purposes. Okay. Imagine you're the defense investigator, the private investigator. You're going to the residence. In back of the residence, there's the trash can where the wallet was located. Okay. These are all your observations. Now, the question here is, are your observations, which I just created this red box here, are your observations of the scene, okay, are they attorney-client privilege? And here, with these facts, they are. If you alter anything from the scene, you're not going to fall under the attorney-client privilege. And as we know, yes, the scene was, well, the evidence was altered, you guys, by our defense investigator moving the evidence, the wallet, from one location to the other. Remember, he delivered it to the police department, the police officers and investigators that were investigating the incident. Okay, when you're doing that, you're altering the evidence because the law enforcement agency, the prosecutors, they cannot observe the wallet in its original state. You moved it, now it's questionable. So look what's going to happen. The California Supreme Court opinion is as follows, and I'm actually going to read you verbatim here. In the present case, the defense investigator, by removing the wallet, frustrated any possibility that the police might later discover it in the trash can. The conduct of the defense thus precluded the prosecution from ascertaining the crucial fact of the location of the wallet. Under these circumstances, the prosecution was entitled to present evidence to show the location of the wallet in the trash can. The trial court did not err in admitting the investigator's testimony. Guys, when you alter evidence, okay, you are not entitled to the protections of the attorney-client privilege. Especially, in particular, if that evidence was gathered as a result of privileged communication, as we see here. Now, we're going to be clear here that this California Supreme Court case did establish that observations by investigators are covered under attorney-client privilege. Okay. Now, these are to the specific facts here. Why is that? Because the client, Meredith, reached out to the attorney, and the attorney reached out to the investigator. Attorney gave direction to the investigator, asked specific questions so that the attorney can prepare for an appeal. Okay. In doing so, the wallet was actually found. So let this be a learning lesson. And not every time is the attorney-client privilege going to be black and white. Just considering how many cases we have discussed today, we discuss a lot. I know not every case is going to fit into your factual situation, but at least you know the rule of law, the rule of case law, and what it is. A lot of you will ask me, Sean, is there a work product doctrine or an investigator-client privilege that is designed just for private investigators? We're going to discuss that. And the short answer, the short way out of this, of hearing this whole presentation, is no. And I will explain why. Let's start off with this presentation like this. So upper right portion of the screen, we have a corporal, senior officer, based on her 2 stripes, depending on what agency she is employed at. And you are the private investigator. Client comes to you and gives you some incriminating information. What are your options? Well, some of you, okay, about half of you come from law enforcement. You might be inclined to notify other law enforcement. Your whole career, you fought crime, you worked on the prosecution side, but you put a lot of bad people away for good reasons. And the information that the client just provided you just doesn't sync well with you. And then there's others, which I have no problem with at all. You might receive this information and strongly believe in your ethics as a defense investigator and tell yourself, well, my job is to not determine guilt or innocence, but to give this person a fair chance at the justice system. And having that type of value system, having those values, you may not be inclined to notify law enforcement. So the question on this particular presentation, on this slide, is, well, can I notify law enforcement? Let's talk about that. Here's a visual representation. Here's some gears. This is a client, private investigator. As you know how gears work, when they rotate, when they rotate one gear, the tooth portion will touch the tooth portion of the other gear, and they will move as if they're one for a common purpose. That purpose, depending on where the gears are attached to, maybe a differential on a vehicle, rotate the tires, rotate the axles, so the tires will rotate, so you'll have a car that moves, right? Well, the objective, okay, of this business profession code section that we're going to be discussing is to keep information private. Because we don't have a work product doctrine or an attorney-client privilege for private investigators, there's something that needs to be done to protect the client. The client needs to feel comfortable discussing information with a private investigator so that the client can accomplish his or her goals as legally as permissible. Here's the third gear. Here's a question mark. Now, normally we would have the private investigator fill in with the question mark, or maybe the attorney. But here, this is third party. So your third gear here could be the police officer, law enforcement deputy, the investigator. It could mean somebody that is outside of the client relationship. So you're working for the wife, okay? husband wants information? No, because the information is only for the private investigator and the client without a full disclosure or without a full release on the agreement. So let's just say the client says, hey, to the private investigator, which would be you, hey, I killed so-and-so. Okay, let's discuss your options. Now, as an attorney, if you're an attorney, if the client came to you for legal advice, criminal defense advice, and they're telling you that they killed somebody, okay, you have a duty to not notify law enforcement. I'll say that again. It doesn't matter what crime was committed, as long as the client is coming to you for legal advice on that issue, you have a duty of not notifying law enforcement. Remember, an attorney-client privilege, the holder of that privilege is the client. The client is the only one that can waive that privilege. Okay? We have, as private investigators, we have 7539 subsection A, Business Professions Code. And let's discuss what this is. It says a licensee or officer, director, partner, or qualified manager of a licensee may divulge to any law enforcement officer or district attorney or his or her representative any information he or she may acquire as to any criminal offense, but he or she shall not divulge to any other person, except as otherwise required by law, any information acquired by him or her, except at the direction of the employer or client for whom the information was obtained. It is clear here that you can go to law enforcement if you receive information on a criminal offense. With attorneys, you guys, they're allowed to go to law enforcement with privileged information, confidential information that their client presents to them if they are about to commit a crime, or they're trying to get the attorney to commit a crime. The most common crimes that an attorney can commit when asked by a client is to conceal evidence, of most of the time a felony. Okay, so the attorney cannot conceal a crime, and some clients may try to get them to help out. They can't, and they have a right to notify law enforcement in that circumstance. But that's it. Here, as a private investigator, okay, it says here you can't divulge any information that's acquired, that you acquire, okay, except the criminal offense. What you can do with the information that you acquire from the client, it's limited to the client's direction. Okay, it says here, except at the direction of the employer or client. Sometimes an employer will hire you. Okay, they are the client. Okay. Let's talk about 7539C. So 7539C says this: a written report shall not be submitted to a client except by the licensee, qualified manager, or a person authorized by one or either of them, and the person submitting the report shall exercise diligence in ascertaining whether or not the facts and information in the report are true and correct. Ladies and gentlemen, you have to know this section. You cannot be submitting reports without the approval of the licensee, the qualified manager, or somebody that's authorized by either one of them. And your reports have to be submitted exercising due diligence. Okay, or it says here diligence. Some of you might ask, well, Sean, the question I have here, number one, is this: What if the client doesn't pay me or didn't pay me? Well, then you have a breach of agreement, most likely in most circumstances. If the client doesn't pay you, you don't give them the report. Okay. Absent an agreement, so let's just say you don't make any agreement at all, they don't pay you, you don't give them the report. Okay, you're not obligated to. Some of you might ask, Sean, what if the client gives me information about a felony crime? Same thing, you guys. It's up to you if you want to notify law enforcement. Sean, how about a misdemeanor? It's the same thing. It's up to you if you want to notify law enforcement. Okay, it doesn't matter if it's a felony, misdemeanor. It doesn't matter if it's an act of terrorism. Hopefully you will, you guys, but I can't instill my values on you. Ultimately, the question at the end is, are you sure that there is no investigator-client privilege here? And I am absolutely positive there is none. Look at 7539A. The code, the section tells us that we can divulge to law enforcement if we receive information that the client has been involved in a crime. You guys, with an attorney, okay, they can't go out divulging information that the client was involved in a crime as long as the attorney is not being used as an instrument for the crime. They're not being used to help conceal the crime, and the purpose for the visit or the consultation, or the purpose for the service is to defend against criminal allegations for this crime that the attorney is discovering here. The same cannot be said for the private investigator. I mean, it's clear. You can tell law enforcement if there's a crime, if there's some type of criminal offense being committed. That's not a privilege. Okay, so who's privileged here? It's nobody. And also because it says except as otherwise required by law, we're at 7539A, except as otherwise required by law. Well, this can be a court order or some other statutory code that is out there. You may have to divulge what the discussion was about under 7539A. For that reason, it is not an investigator-client privilege. Okay, you guys, in 7539A and then at 7539C, discovery proceedings are very vulnerable. I'm going to say that again. 7539A and C, during a discovery proceeding, the information that is given in confidence, even if it was a discussion, it's vulnerable. It's open to discovery. That's one of the reasons why I like to put an attorney into the case. But that was topic of discussions that we had previously. Now, as a work product doctrine is concerned, 7539A, do you guys see any work product that is being protected here? I don't see anything. It tells us that we can notify law enforcement if we acquire information of a criminal offense. It tells us that we can't divulge information to anybody but the client or the employer, it says here. But there's no work that's being protected as the work product doctrine is involved when an attorney is in the case. And then 7539C, there's no work product that's being protected. It just tells us who we can submit the report to, okay, and by whom. Okay, that's it. And it also tells us that we have to do our due diligence. But there is no work product that's being protected here. Okay, no work product being protected. There is no investigator-client privilege here. 7539A and C. So this is an interesting case that came out of the 4th District, California Court of Appeals, 1997 case. This is Flynn versus Superior Court. You guys are going to love this case. What we have here is the plaintiff. The plaintiff is Flynn. Flynn belongs to a law firm. And Flynn saw a male subject going through the law firm's dumpsters. He was gathering 2 trash bags on the plaintiff's property. The subject fled in a van, and in the process, apparently he attempted to strike, or he did strike, the plaintiff. The van was owned by a man named Peter Barranco. And guess who Barranco was employed by? Well, Barranco was employed by Jonah Bowling, who was a licensed private investigator at that time. Okay, so there's a reason why he was going through that trash can. During the deposition, Flynn, who's a plaintiff, he demanded Bowling disclose the identity of her client. And she refused. She argued 7539A. That's the section, Business Profession Code section that we just discussed. Remember, under that section, the conversation, the communication is confidential. However, when there's a court order, okay, that information is disclosable in a court of law. Here, there was no attorney that was involved with this investigation. It was just the client and the private investigator. Private investigator Bowling refused to identify her client. What do you think? Do you think that 7539A is going to allow her to continue refusing to identify her client? Let's talk about that. So this is how the Court of Appeal interpreted 7539A. The language of the statute is clear that it is only information that is acquired for the client that may not be divulged. So does it look like to you that the client's identity is considered information that's acquired? Let's see. Court of Appeal said this, in their opinion: information acquired for the client is information which the investigator acquires on the client's behalf while the investigator is in the client's employ. For example, information developed during the course of the investigation conducted for the client. And what they did is they did a plain reading. A plain reading of the statutory language demonstrates the identity of the client does not fall within the scope. You guys, there's very rarely are you going to find any interpretation of 7539A. Issues involving 7539, if any, they die at the Superior Court level, if even that. But it looks like they rarely make it to the Court of Appeal. In the last hour and a half, folks, we discussed so much information. We went to great detail talking about the attorney-client privilege. We went to great detail discussing the work product doctrine. And we went into great detail and discussion of how investigators do not have their own privilege. They must be attached. If they want to have communication privileged, they have to be attached to an attorney and fall under either a work product doctrine or the attorney-client privilege. If they truly want their information protected from compulsory disclosure, especially at depositions and other court proceedings. We discuss numerous case law. We discuss several California Supreme Court decisions. Most of the cases we did discuss involve California Appellate Court. You guys, the cases that I discuss is what is current as I speak right now at this moment. You also have to keep in mind that your facts might differ from all the cases that we discuss. There might be some other details that might change the overall outcome beyond what we discuss in this presentation. Ultimately, I hope and I feel confident that you know a lot more about the attorney-client privilege. You know what 7539 in the Business Professions Code is. You know what 7539C is. And I think that you're going to be doing such a greater job out there.